This is our presentation for this evening. This is just for context for everyone. I requested that our local solicitor, Stephen O'Melia from Miller Thompson, come present to Council on strong mayor's powers, as the province has granted them to the Township of Wilmot among over 100 other municipalities in the province. And so really what I wanted this to be was informational, so that myself included, we can all understand what exactly that legislation entails. And at this point, I mean, I will let Stephen speak, obviously, but I see it as a set of potential tools, but I think it's really important for Council as well as the general public to better understand them, as this will change the potential, not just for myself as mayor, but for those in the future who choose to run for council positions. So this is really informational, and to that point, councillors, I would just remind you to, if you have questions, please keep them to technical questions about the legislation. We're not getting into opinions. As stated, the province has already made this decision. So with that, I will turn it over to Stephen O'Melia, our solicitor, to provide his presentation.
Yes, thank you very much, Mayor Sallin and the members of council. I've been more used to appearing through Zoom at these meetings. It's kind of nice to do the drive. It's a very nice drive on a night like tonight. Although I got caught in the Snyder's Road shutdown, I didn't realize I had about 6 or 7 minutes to the drive. Anyway, I have a PowerPoint presentation that I'm going to run through, and I brought paper copies so that you can take them away, so in case there's anything that kind of we go through too quickly, and certainly happy to try to answer any questions at the end of the presentation. So if I could have the next slide, please. So the history of strong mayor powers, you're probably familiar with it. It was a special section that was added to the Municipal Act, sort of right in the middle, and it was passed pursuant to the Strong Mayors Building Homes Act of 2022. But at the time, it was only applied to the cities of Toronto and Ottawa. So it was very limited power, and just those two mayors received the powers. In 2023, it was extended to 27 other larger municipalities. And then that number was later increased to 46, and now this is the largest expansion. This latest expansion is 169 more municipalities, bringing the total to 215 as of May the 1st of 2025. And this applies just to single tier and lower tier municipalities. It does not apply to counties or regions. So it's only the level that you're at that get it, or the larger single tier municipalities. Next slide, please. So the stated reason for the power was that the province wanted to promote prescribed provincial priorities, which were set out in the regulation, and the original ones that were established in 2022 have not changed, and there's just two of them: to support and encourage the approval of new housing, and to support the construction and maintenance of infrastructure to support housing. And the exercise of strong mayor powers isn't solely limited to those priorities, but many of the powers are strictly limited to the pursuit of those two provincial priorities. More priorities could be added at a later date, but at least since the enactment, that has been the focus. Next slide, please. Thank you. So there are three broad categories that I've summarized there. The first one is organizational powers. And so that's the power to appoint or dismiss the CIO and heads of organizational units, although there's a long list of exempt positions that we'll get to on the next slide. The mayor has the ability or the discretion to determine the organizational structure of the municipality, and to establish or dissolve council committees and to appoint chairs and vice chairs of those committees. And when we get to the slide dealing in more detail with organizational powers, there's also an ability to direct staff to provide advice and to undertake research in pursuit of the provincial priorities only. The second broad category is legislative powers. And that's the mayor has the ability to require council to consider a matter at a council meeting. That would be done with advance notice. It would be on the agenda, and it would be simply the ability to put matters directly on the agenda. The mayor also has the ability to require council to vote on a bylaw at a council meeting. So again, just more taking the ability to take a greater initiative if that's the choice. It's an optional power. And then finally, the power to veto bylaws adopted by council, but that's subject to an override. So we'll get into that in a bit more detail. It's kind of confusing. although when you sort of walk through it, there's a series of steps that don't, once you sort of go through it slowly, are not that confusing. But it at first, when you see the flow chart, it looks rather confusing. And that applies to bylaws under the Municipal Act, bylaws under the Planning Act. There are a few bylaws that it does not apply to. The Development Charges Act is one of those, but for the most part it applies to all bylaws that dealt with by council. And then the third broad category is the budget power, and that's to prepare and present an annual budget by February 1st of each year. So the normal starting point when I have been practicing municipal law is that staff prepare the first draft of a budget. It comes to council, and that sort of starts the discussion. The structure now would be that if the mayor chooses to, it would be the mayor's budget that would start that discussion. And then council would then have the ability to propose amendments to that budget. And then the mayor has the power to veto those amendments. And again, we get into that veto discussion. It requires a 2/3 vote of council to overturn a veto. And then the mayor finally has the ability to present in-year budget amendments if a supplementary levy is required. So next, thank you. So one key thing is the power must be exercised in writing and done in accordance with the regulations. So by the next business day after the exercise of this power, there needs to be a written document setting out which power was exercised, and that needs to be provided to each member of council and the clerk. And then the record must also be made available to the public, subject to MFIPA. You wouldn't put private or personal information up there, but subject to that caveat, it needs to also go on to the public. And Ms. Boz provided me with the website link that the township is using to do that. So that would be the site that members of the public could go and they could track through the various exercises of the power. And my last bullet, those are sort of my words. I always picture it as the mayor stepping into the shoes of council. So the mayor doesn't have any additional powers or any lesser powers. Effectively, when the mayor is exercising strong mayor powers, she's doing so as if it was council doing that, and has the same authority and associated powers that would go with that, but no greater or no less. Next slide, please. So organizational powers in a bit more detail. So this is the ability to decide ultimately sort of which departments exist and how the municipality is set up. The default right now is that things would continue as they are. So unless changes are made, the status quo prevails. But there is that ability to change that, and that would be in the hands of the mayor. It does include, as I mentioned, the powers to carry out employment powers with respect to the CAO or the head of any division or the head of any other part of the organizational structure. So that's fairly broad, and it could extend into the organization. If someone is the head of a particular division, technically that would apply. The third bullet is fairly important. There's a power to direct staff in writing to undertake research and provide advice on policies and programs. But again, the key is related to the strong mayor powers, and written notice of the exercise of that power must be provided in writing to both the clerk and the CAO by the next business day. So again, the goal is transparency. And I will say it doesn't necessarily have to be provided the next day. It could be provided the same day, but it must be by no later than the next business day. The next slide, we get into some pretty small font there. These are the exemptions of people who are not, or positions that are not subject to the strong mayor powers. So there's the clerk and the deputy clerk, the treasurer and the deputy treasurer, an integrity commissioner, an ombudsman, auditor general, chief building official. In this municipality, chief of police and medical officer of health wouldn't apply, obviously, but a fire chief would fall into that as well. So there are certain positions that are just the same as they always were. Council maintains the power to appoint or dismiss those positions. And you're already there. That's great. The legislative powers, if the mayor is of the opinion that considering a particular matter could potentially advance a prescribed provincial priority, the mayor may require council to consider the matter at a meeting. And so that's one of those powers that is in fact tied to one of those two priorities, housing and infrastructure, that we covered right up front. If the mayor is of the opinion that all or part of a bylaw could potentially interfere with a prescribed priority, the mayor may provide written notice to council of intent to consider vetoing the bylaw. So the veto doesn't necessarily come out of the gate. The bylaw would be passed, and if the mayor is concerned, there would be a notice to say that there is a consideration being given. And that must be provided to council within 2 days of the bylaw passage. Now, those opinions, both the first bullet point and the second bullet point, are in the sole discretion of the mayor, and there is a fair liability protection that also applies to municipalities general for the exercise of that authority. But the one key provision is that it must be that opinion must be formed in good faith. Next slide for the veto provisions. So within 14 days, so the notice must be provided within 2 days, the notice of intent to consider. And then within 14 days of the bylaw, no later than 14 days, the mayor must determine whether or not the veto will in fact be exercised. And so if the bylaw ultimately is not vetoed, it comes into effect on the earlier of 14 days after the day of bylaw passage or the day of written approval by the mayor. So it's in theory possible for the mayor within 2 days to say, I'm considering vetoing this bylaw, but then after consideration to make the determination, I won't veto it after all, and a written approval can be issued at any time, and that would stop the clock from ticking, and the bylaw would come into effect on that date. Now, the recommended practice, and I understand from speaking with Ms. Boz that this is already being pursued by her, is to have the mayor issue written approval of bylaws on the date of passage if there is no concept of considering a veto, and that keeps the uncertainty out of it, because ideally bylaws, if they aren't going to be vetoed, may as well or should come into effect on the day they were enacted. There shouldn't be a limbo period. And so that's best practice. That if there's no intention of a veto, the mayor can immediately approve it, and then the 2 days and the 14 days become a moot point. And I'm thinking, for example, something like an interim control bylaw. I don't know if council has had recent experience with that. You would not want to leave that in limbo, because the whole point of that is to do it quickly. And so again, either you approve it immediately or you exercise the veto fairly quickly, and either way you're getting certainty. So the next slide deals with these time frames. So when the veto is exercised within 2 days, then by no later than the next business day, the veto document should be provided to each member of council, and again made available to the public on that public website. And then within 21 days of notice, council may override the mayor's veto by a 2/3 vote. So in this council's case, it's a nice easy math. 4 of 6 members is sufficient to override a veto. The mayor does get to vote on the override vote, so the mayor would be one of those 6 votes. And the way I read the legislation, it would have to be 4 members. Even if there were only 5 members present, you would still need that number of 4. It doesn't say 2/3 of the members present and voting, it says 2/3 of the members. So numerically, you would need the full 4. It has gotten more confusing when there are councils of 7 or 9. It can get rather tricky. If council does override the veto, the bylaw is deemed to be passed on the day of the override vote. So there's no further requirement for the mayor to approve the overridden bylaw. The override ends the matters. So the next page is the flow chart, and I won't take credit for preparing this, but I have reviewed it, and I think it is. I think it accurately sort of sets out the steps required. It was originally, I believe, appeared on a public presentation in Clarington, but Clarington also had borrowed it from somewhere else. So I wasn't able to attribute the original author, but I have vetted it, and it kind of gives you the flow chart as to how things are done. Next up, the legislative power in terms of passing bylaws. So again, we've covered that in the 3 broad categories, and this is just drilling down a bit. If the mayor is of the opinion that the bylaw could potentially advance one of those 2 prescribed provincial priorities, the mayor is able to propose a bylaw and ask council or require council to vote on that bylaw. Now, the mayor must provide an advance copy of the bylaw and the reasons for the proposal, so almost the equivalent of a staff report. And then that power is subject to the normal requirements. So, for example, a Planning Act bylaw would still require public notice. You can't just throw it on the agenda, just as council could consider a zoning bylaw without having prior public notice. a mayor-initiated bylaw would have to go through that same form of public notice. Now, in this case, a vote of more than 1/3 is sufficient to pass the bylaw, and the key is the more than. So it's not just a third, like the 2/3 vote, it's more than 1/3. So in this case, that would require 3 of 6 members. So it would create a bit of a different situation. 3 of 6 would normally be a tie, and therefore it would fail to enact the bylaw. 3 of 6 would be sufficient in this case. And then finally, budget authority is the last large category. So the powers and duties, and this is right from the legislation, the powers and duties of a municipality with respect to proposing and adopting a budget are assigned to the mayor. And again, the phrase sort of mayor's budget has been used in places where this has been in place for a while, Toronto and Vaughan and elsewhere. And so the mayor must prepare, if that power will be exercised, the budget must be prepared and provided to council consideration by no later than February 1st of each year. And council has 30 days to pass a resolution to propose amendments to the budget. And if no amendments, the budget takes effect on March the 3rd. So it's 30 days after the budget deadline date. I guess that would be March 2nd in a leap year. Council has the ability, and I didn't put this in here, council could choose to truncate that 30 days and make it a shorter time frame. I don't know why you would, because there's no prohibition against acting more quickly. That's the outside limit, so I don't know why you'd put yourself on a tighter time frame. But there is that ability if for some reason council wished to do that. The mayor, again, we're back into the veto system. The mayor may veto those proposed amendments, and then a 2/3 vote of council would be required to override that veto. And if the mayor does not present a budget by February 1st, authority reverts to council. Now, again, in practice, I've sort of spoken with different people in different municipalities. I don't think anyone expects the mayor to sit at his or her desk and sketch out a budget all by themselves. Obviously, the normal input that's obtained from staff and from all departments would be necessary, I would think, in order to do that. And so really, when I view it, it's almost more who presents the first draft. And it's been taken from the staff specifically to the mayor to start the discussion with, in this case, which he believes is the best approach for budgeting for the municipality. Next slide is the in-year amendments, and again, I covered that briefly up front. Slightly different, tighter time frames. The mayor may propose a mid-year special levy, and council has 21 days to approve or propose amendments. And then the mayor may veto those amendments within 26 days of the first proposal date. And then again, a veto subject to the standard 2/3 veto override within 36 days. So again, I've borrowed the flow chart, and it does accurately set out sort of the time frames in terms of a flow chart for the actions that are taken. And that's why I thought it was important to bring paper copies so you can take that away from you, because it would take a long time to cover that, but effectively that's how it works. In terms of delegation of authority, the mayor may delegate just some of the strong mayor powers in the mayor's sole discretion. So the organizational powers may be delegated to council or the CAO, and that would be with respect to particularly the organizational structure that can be delegated back to staff if the mayor chooses to. All delegations can be undelegated, so there's even if power is delegated, it doesn't mean it can't be retrieved. Ultimately, it's in the mayor's discretion. The legislative and budget powers, I say delegated to council, that might not be the right word. If the mayor doesn't propose the budget, then it reverts to council. So maybe delegation isn't the right way to put it, but if the mayor chooses not to introduce a budget by February 1st, then it reverts to council. And so the authority dissolves for that year. And I've already covered the last bullet. Any delegation can be rescinded in the mayor's discretion. So briefly in summary, the last slide, this does represent a significant shift in how municipalities operate in Ontario. A lot of U.S. cities, Chicago, New York, have strong mayors that have a lot of additional powers. In Ontario, people were often surprised to find that effectively from a technical legal perspective, the mayor was just one more vote on council. And this does alter that framework. The new powers are extensive, but they aren't unlimited. And in many cases, they're directed at provincial priorities, and that was the key, and that's why they were introduced. And then finally, the powers, again, we've covered this, but we'll keep repeating it. They must be exercised in writing, and then that writing must be provided to designated persons within designated timeframes and then made available to the public. So it isn't intended to be it's intended to be as transparent as the exercise of council of its powers. So I think that summarizes it. There are some sort of small fine points I didn't bother cluttering up the PowerPoint with. I'll mention one, that if there was a vacancy in the mayor's office, an appointed mayor would not get the strong mayor powers. An elected mayor would. So if there was a by-election for whatever reason, an elected mayor would step into the strong mayor powers, but an appointed person who became mayor would not receive those powers. And similarly, if for some reason the mayor is away from the municipality and an acting mayor is in the place, the acting mayor does not get those powers. The powers are personal to the elected mayor and do not transfer with the position. It's a personal issue with respect to the democratically elected mayor. And so those are my comments, but again, happy to listen to and attempt to field any questions.
Thank you very much, Mr. O'Meara. Councillor Wilkinson.
Thank you. Through the chair, listening to the presentation and just reviewing your material here, you've mentioned the veto powers extend to bylaws and typically ones that are related to the provincial priorities. So what about, say, if council were to pass a resolution or give direction related to policy that isn't necessarily passing a specific bylaw by any means? Does the mayor's power extend to that?
Sorry, can you repeat that last bit?
No problem. So you've mentioned that it relates specifically to bylaws. I guess my question is, if council were to pass a resolution or a motion or make a decision related to policy that doesn't necessarily translate directly into a bylaw, does the mayor's power extend to that realm as well?
It does, yeah. There's a section of the Municipal Act that deems resolutions to be bylaws, and normally there's a confirmatory bylaw that wraps everything up in a bylaw. So yeah, the distinction between a resolution and a bylaw is not a distinction. It would apply to both. Yeah.
Councillor Dunstall.
Thank you, through you, Mayor. Thank you, Stephen, for that presentation. That answered some of my questions, but I did want to ask you, it's specifically for the provincial priorities, which would be housing and related infrastructure. Those are the two elements that must be involved for the mayor to have strong powers on any particular item. They have to be related somehow to those two priorities.
Yeah, unfortunately, it's not quite as simple as that. Some of the powers do have to directly apply to those powers, but not all of them. So, for example, let's say the organizational structure issue, you don't necessarily have to say we're changing our organizational structure because that will bring more housing. That's just a power standing unto itself. But the veto power, so the power to veto a bylaw, that must be tied to an opinion that the bylaw would frustrate one of those provincial priorities. So it depends on the specific power that you're speaking about.
Councillor Cressman.
Yes, since you are Ontario Municipal Association representative, what is the Ontario Municipal Association's view on strong mayor's power? I realize it's been passed. You have talked about the challenge of recruiting younger people. I would ask the question, what's the challenge of recruiting people to run with limited authority?
It's definitely a conversation that we have had, and I don't want to misrepresent Amos, so I will clarify this is my interpretation of the conversations that have occurred around our board table. There isn't clear direction right now. There are very divided opinions around the AMO board on the powers. However, to your point about recruitment for people to run for council, whether for mayor or for councillors, that is a conversation we are having actively and trying to address through AMO's Healthy Democracy Project. And we've expanded kind of, not the scope of the project, but some of the focus as Strong Mayor's powers have come in of how do we, and when I say we, I'm talking about as a province, as educated and informed electorates, how do we get people of all ages and backgrounds to run? Staff have been working on how to focus that and really highlight the strong mayors. A big component they're doing with that is trying to do educational components to the electorate. So activities like this where we have an open public session, information on what exactly that entails. Do we have a perfect solution? No, we do not. If you have suggestions though, councillor, or anyone for that matter, honestly, we are very open to that at AMO.
Yes, so just to follow up, I would view this as reducing the role and function of individual councillors. And now I realize not to give opinion, but we become then advisors and observers of decisions that the mayor has made. And I'm not thinking of you specifically, but in general, and I think that takes away from the intention of people running and being part of the decision-making of a local municipality. But again, I realize it's passed. I'm not, that would be my opinion as we look at this. And I was looking for this at noon hour. I was looking at it for 3 o'clock this afternoon so I could come better informed to this meeting, because I realize there is a lot of implications as we look forward, even to close out the current term of our elected councillors.
Any other questions, councillors? Seeing none, we don't take questions from the gallery.
And
yes,
through you, Marcel, and if I may, just I was thinking further about Councillor Dunstall's question. If you want to put sort of a broad category, the legislative powers of those 3 broad categories, those must be exercised in pursuit of provincial priorities. The other 2, the budget powers and the organizational powers, don't have that prerequisite. So I think that's probably the best shorthand way to think about it.
Very good. Councillor Wilkinson does have a question now.
Through the chair, just related to the budget, oftentimes, at least through this council, it can be a very time-consuming exercise, to say the least. So sometimes budget season starts, we'll say December, January, and we see a presentation from staff. In this case, you've suggested that one of the things that would happen would be that they would work in collaboration, but then ultimately a budget would be presented either by the mayor on February 1st. If not, then it would revert back to staff bringing forward a budget. Is that accurate? Like we won't see a budget proposal from staff at all until the mayor's deadline is either passed or waived.
Correct.
Okay.
Yeah, through you, Mayor Sullivan, that's right. So February 1st is the date. If it's waived, then you don't need to wait until that date, but otherwise it would be the mayor's authority until after that date. And again, just anecdotally, just speaking to people who have been in municipalities that have done this, the process to arrive at the first draft is still very similar. Obviously, no one person can sit down and just come up with a budget. There's still a process of input and collection of data and information. But the intention of this legislation is that the mayor would then, if that power is being exercised, would take that information and put the first draft on the board.
And just to supplement to that, both for council and the general public, currently am in discussions with staff of how our process is going to go forward for the new budget. We haven't fully come to that, but at this time we are still looking at in the fall at some point is when the budget will be tabled. And then I guess my question on that is tabling the budget. It's once it's tabled, there's the 30 days unless council decides to make it shorter, correct? It's not. the March 2nd date, like that date is only exists if it's tabled on February 1st?
I'm 99% sure, but let me check. I've got the sections from the Act here. Yeah, that's correct. It starts with the provision of the budget. That would start the clock running. So it doesn't wait until February the 1st. Once the budget is introduced, then those timeframes begin. So council would have 30 days from the date of the introduction of the budget to propose amendments, approve it or propose amendments, and that would flow through.
Thank you. And yes, once staff and I sort out how we are proceeding with the budget process, we will be notifying the public as well as council as to how it will proceed. Yes, Councillor Martin.
Through you, Mayor Salonen. So this just brought up a question for me on that topic. And I haven't totally thought it through yet. So we could work on the budget in the fall as you're proposing, Mayor Salonen, and even finalize our budget, but then based on these powers, is it fair to say that, I'm not sure if you would want to, but that you, Mayor Salonen, could then veto the budget later because you have until February 1st? Is that what this means?
Sorry, and just to make sure I was making sure I was looking at the right dates. So the question would be, I think the issue is that would be the mayor wouldn't veto the budget. In that case, the mayor would veto amendments to the budget. Did I understand the question correctly?
I guess I was just trying to, again, through you, Mayor Salonen, I was just trying to understand what this means. Like, if we make a decision and then say this is our budget, but you would technically have until February 1st to make a change, is that right, or have I misunderstood that?
No, so the time frame works like this. The mayor can propose a budget at any time, really, at any time that makes sense, but by no later than February 1st of each year. And so once that budget is introduced, and I have found the section, it's in the regulation, that there is then a notification process to council, but then within 30 days of that date, council must either approve it or propose amendments. And then those amendments go back to the mayor, and the mayor can either accept the amendments or she can veto those amendments, in which case it goes back to council to consider whether it wishes to override that veto. And that's when you get into the 2/3 of council votes. So 4 votes required to veto to override the veto, excuse me.
I will just add one more supplement though. And there is the part that does give the mayor the ability to add in, like, midway through the budget, a special levy, should they choose. So I guess just to your point, no, the mayor doesn't have the ability to change the budget once it's approved, but they do still have abilities to, in essence, change the tax levy through the other pieces of legislation. So just so that everybody understands what is fully detailed in that authority. Yes, Councillor Wilkinson.
Actually, through the chair, are we done discussing the budget-related items? If not, I have an unrelated question on another piece.
Yeah, if it's about strong mayor's powers,
yeah,
it's free game.
So through the mayor, a question just occurred to me that you had mentioned regarding the veto power, that it needs to essentially be a very strong veto requiring 4 votes, not necessarily representative of what quorum would look like at the time. So my question would be, what about in the case of, say, a pecuniary interest where someone has to recuse themselves? Would that have any effect at all on, in that case, the quorum, because it essentially is eliminating one individual?
That is an excellent question. I would think you would have to. I'll say the legislation does not provide for that. It simply says a 2/3 vote. I think you would have to adjust that downwards to reflect the fact that there are only 5 available votes. So it would be 2/3 of that. Now that would still be 4 votes numerically because it has to be at least 2/3. So, but if you got down to 4, you would need 3 votes. No, so I think by operation of law, you would have to be able to adjust that. And I will say similarly, if I could through you, Mayor Sullivan, and another footnote, the Municipal Conflict of Interest Act still applies even if the mayor is exercising these powers outside of a meeting scenario. So if there was a pecuniary interest with respect to a zoning bylaw that applied to a specific property, that would lead to an inability to use those powers in that particular instance. You'd still have to declare the conflict even though you're not in a meeting. And generally speaking, people aren't used to declaring conflicts under the MCIA when they're not in a meeting, but that would still apply.
Councillor Cressman?
Yes, this is just a process question through you, Mayor. Will we have the opportunity after we read this and digest it, and if we have further questions, to maybe have you online or whatever to get further information? Because, like I said, studying for a test and having the test at the same time and answering questions or requiring it is pretty tough, especially with advanced age. So I think the mayor has had the opportunity to see this, has had discussions at Ontario Municipal Association, and so I think it would behoove us as a council to be able to think through some of these, get further questions and clarity so that we move forward with clarity on this. So.
Yeah, I think I'd be in staff's hands, the clerk and the CAO on that matter, but yeah, that makes absolute sense, and certainly if there are any supplementary questions, I could answer them in writing or I could re-attend, whichever makes sense.
And I'm happy to add further supplement. Clerk Boss is also becoming our in-house expert specialist, so she'd be a great first place if council or the general public has questions about it, and we most certainly can reach out to Mr. O'Melia anytime that that's appropriate for any of us to get this information.
Through the clerk, yeah, exactly.
Yeah.
It would need to be, yeah. And I'll say, this will sound like I'm trying to butter her up, but I was impressed that she was already ahead in terms of having this process in place to avoid a delay, an unnecessary delay. If there's no intent to veto a bylaw, there's no point waiting 14 days to find out that there was not a veto. You may as well get that done right away, and that's definitely a best practice. And there are other best practices out there that I know the clerks across the province are sharing with each other.
Any other questions at this time, councillors? Okay, seeing none. And I will just note, I know some people in the gallery wanted to ask questions. Again, our procedural bylaw, we do not take questions from the gallery. However, please do feel free to reach out to council, and we are happy to work on getting you an answer on that. But we just don't take them from the gallery during meetings. So thank you very much, Mr. O'Melia, for coming in.
Thank you all. I'll do my route around Nafziger Road and go back. Yes. Take care.
Thank you very much.
You can actually go straight out.
Oh, yeah?
Yeah. Straight out and down the